Hi, and welcome to today's BCLT Privacy Law Forum Life Sciences session. My name's Allison Schmidt. I'm the director of the Life Sciences Law and Policy Center here at Berkeley Law. It's my pleasure to welcome Rachel Zuraw today, who's going to be talking about matrices of privacy, helping us think about what the consequences are of our wearables from a privacy perspective. I've had the pleasure of co-teaching classes at Berkeley Law with Rachel on several occasions. And I've always been really impressed with her knowledge of the intersection of privacy, healthcare, and life sciences, which is why I thought it was a really natural fit to bring her to you today. So prior to her time at Berkeley Law, she practiced as a litigator in the Bay Area. She was a litigator at O'Melveny and Myers and also at Hanson Bridget. She's worked on class action, IP, technology, and healthcare litigation issues. Prior to entering private practice, Rachel taught at Drexel University School of Law and the University of Pennsylvania. Her formal training comes from Princeton University, and her law degree and master's in bioethics are from the University of Pennsylvania. So, with that, I'm going to turn things over to Rachel to tell us about a rapidly moving and really fascinating area of the law. I'm really looking forward to this. Thanks so much, Rachel.
Thank you for the very kind introduction, Allison. And I'm really happy to be a part of this forum and talking about something that frankly has been fascinating me for some time. Um, as Allison led us off, this is an incredibly rapidly evolving, rapidly changing area of law, commerce, and human practice. So that said, let's dive into it. So, just a quick overview of what we're going to be thinking about today is the concept of the intersection of privacy and health data. Little bit broader and wonkier and weirder than many people assume at first glance. Then thinking about what are our wearable devices doing? What's their purpose? Why do we want them? Why do corporations promote them? And then taking a look at, does age matter here, and how should we be prepared for what is coming in the future? All right. What is privacy? There are a lot of different perspectives out there, and I know that you're currently listening to a privacy law forum. You probably have a lot of, understanding of the law of privacy. Don't worry, we'll be getting into it a little bit. But what is privacy from a philosophical, ethical perspective? Why do we care about this? A few different perspectives on it that I really enjoy. Richard Posner. Privacy is mainly about trying to improve your social and business opportunities by concealing the sorts of bad activities that would cause other people not to want to deal with you. Brandeis, the right to be let alone. Helen Nissenbaum, a wonderful modern philosopher. Privacy is a messy and complex subject. And Judith Jarvis Thompson, perhaps the most striking thing about the right to privacy is that nobody seems to have any very clear idea what it is. And that is the landscape in which we find ourselves when we are thinking about how do we interact with wearable medical devices, and how do the companies, the agencies, the practitioners that rely on and manage them, how do they conceive of the rights and protections for their end users? So, a pretty straightforward way to shape this conversation, to shape the way we think about it, we step back towards HIPAA, as we have on our next chart here, the Health Insurance Portability and Accountability Act. So HIPAA is probably the most well-known privacy protection for personal health information in the United States. Defines your personal health information, protected under HIPAA, as any information in the medical record or designated record set that can be used to identify an individual and that was created, used, or disclosed in the course of providing a healthcare service such as diagnosis or treatment. So, This is what we think of often as our personal or protected health information. That is just a small slice of what we need to be thinking of in today's privacy landscape. I wanted to just address this early on. We're going to be coming back to this slide about key regulations to be aware of if you are interested in the intersection of privacy and wearable medical devices. We're operating from a US-based perspective in this talk. Nonetheless, I am including the GDPR, the General Data Protection Regulation, because of the incredible reach that it applies, for example, even to any European citizen, even if their data is being processed outside of Europe or if they are visiting a location outside of Europe, any smart company or corporation is adherent to the GDPR because it most often has the highest privacy protection standards. HIPAA, as we've mentioned, the California Consumer Privacy Act and California Privacy Rights Act, CCPA, CPRA. And finally, since we are talking about commercial devices here, the Federal Trade Commission Act. And that's where I actually really want to direct your attention today. Because, as I said, when we're talking about privacy of your protected health information, a lot of people think it's safe because they're like, well, it's protected under HIPAA. This is my health information. HIPAA only applies when your data is handled, as listed here, by healthcare providers, health plans, or their business associates. So, as we're about to talk about, this is going to cover some data generated by consumer wearables, but most of it is actually not protected under healthcare specific privacy regulations. These are consumer wearable companies that are providing your greatest collection of data and the most popular wearable devices. So they are not providing specific privacy protections for your healthcare information. The GDPR does a little bit more. It's, of course, it's a very broad privacy regulation. It does have some specific special categories of health data that require explicit consent to share, minimization of the shared data, and then some additional strict rules for handling the data and responding to any breaches. But again, that's not really getting into the nitty-gritty. So why are we talking about this? A lot of people have talked about the Internet of Things, all of the devices that we depend on right now that are collecting and sharing information. Let's think today about the Internet of Medical Things. And these are primarily the devices that we rely on to collect and monitor our healthcare information. And these are incredibly useful devices. Many of you are probably wearing one right now while you're listening to this, an Apple Watch, especially the newer generations, but pretty much any iteration of the Apple Watch is considered to be a consumer health device, collects your heart rate information. Recent models can detect whether you are in atrial fibrillation. They can check on a lot of other things to monitor your health information. So that's a great example of one of the consumer grade, consumer health wearables. Generally, you're not doing anything official with that data, but it is collecting it anyway. We also have medical or clinical grade wearable devices, which again, many people have probably had experience with earlier generations of those, things like a Holter monitor for monitoring your cardiac activity when you go about your day and bringing the results back to the hospital. But in modern days, we have, things like continuing glucose monitors, which are perpetually monitoring your glucose levels for individuals in need of that, giving you feedback can sometimes giving that feedback directly to your medical team. Also, there are a number of in-home devices that fall under the category of Internet of Medical Things. We're going to get back to those in just a second. Clinical and hospital-based devices as well. Why? Okay. A great way to narrow down the lens of the difficult fit between the right to privacy and the interest in using and accessing our wearable medical devices is found when you consider aging populations. So let's talk about that for a second. We have an aging population in the United States. Right now, surveys estimate that the number of adults in need of long-term services and support, LTSS, is approximately 14 million. We're expected to go up to approximately 50 million individuals in the United States alone in need of LTSS by 2050. LTSS being assistance for someone with a chronic illness or disability who faces physical or cognitive limitations, anything that is required to help them with their activities of daily living, personal care, bathing, toileting, or the instrumental activities of daily living, IADL, which are things more like managing your medication, managing your finances. So, what happens with all of these people in need of long-term services and support? Where do they go? Historically, Um, well, if we go back, 100 years or so ago, individuals were just expected to age in the home, rely on family and community support. 1935, we are really seeing the beginning of the government becoming deeply involved in aging and in supporting the aging population. And that was more thinking about how do we pay for physicians? How do we pay for facilities? Then, moving back beginning in approximately the 80s, was the introduction of home and community-based care waivers pursuant to Section 1915C. Those have been expanded until today. They are the largest payer of community-based long-term services and support under Medicaid. As of 2015, the latest numbers they've released was about 55% of payment for long-term services and support are through home and community-based care rather than in long-term care facility. So this has generally been promoted as increasingly patient-centered, allowing people to customize the support that they actually need, and the ever-popularized phrase, aging in place. So, aging in place is the idea that of receiving support, and I promise we're going to get back to privacy and wearables in just a minute. This detour makes sense. Aging in place is an idea of getting the support that you actually need, as opposed to a one-size-fits-all approach of relocating out of your home into a facility, but getting the support, the individualized support that someone needs for their activities of daily living or the management thereof that allows them to remain in their community, in their space, in their routine. There are, of course, and there are a number of studies that show greatly increased happiness, health outcomes, longevity for individuals who have the support necessary to age in place rather than to prematurely go into a facility if they are able to maintain some degree of independence. But how do we actually make aging in place work, especially in the current landscape where, as we know, there are significant cuts being enacted as we speak to government payment for long-term, for LTSS and other long-term care. So How do we make all of this possible? It is with in-home devices and wearable medical devices. These are creating an absolute revolution for individuals seeking to age in place. That there are fall monitors now. They can detect, actually, Apple Watches can function as sort of primitive fall monitors. There are a number of other devices that function to alert a medical team or your family, depending on the device you choose, or both, of whether or not someone has fallen. It's no longer relying on someone to be able to press an emergency alert button. Um, there are devices, again, as I mentioned, that allow continuous glucose monitoring, that monitor heart rate, disordered heart rate, can send alerts to the individual if they are sufficiently competent to process them, or to their family, or to their medical team. All of this is incredibly valuable to allowing someone to remain in their home, have fewer monitoring appointments, not need to have someone in their home watching them every moment because a team can respond if an incident happens. So, unquestionably, very valuable tools, especially as individuals need to cut costs for their aging, as less is being covered by the government and as they need to prioritize aging in place and using their own resources. But um, all of these devices, of course, as they are collecting this helpful information, the things that it says on the outside of the box that the elderly individual purchasing it may be interested in them collecting. They are also collecting and processing all sorts of other information that can be used to individually identify that individual. So their location, their heart rate, if it's a device that enables browsing and visiting the internet, like again, the ever popular Apple Watch, their browsing interests, so many things. It is very easy. If you take the data from an Apple Watch in particular, even if the data is anonymized, if it is aggregated, you can re-identify the individual who generated all of that. And let's head back to the GDPR and to the CCPA, CPRA, all of which require corporations collecting private information about individuals to de-identify that data. But when you're talking about collecting the incredibly intimate category of medical information, re-identification, experts say, is relatively straightforward. It is also relevant that a lot of this data is very, very pertinent to data brokers for marketing purposes. A really interesting example is, let's say your Apple Watch is picking up that your heart rate is always elevated when you are commuting, because it is picking up on your location data as well as, if you ask it to, monitoring your vital signs. That can then be interpreted that this is a time period which reliably leads to stress, which then you can receive promoted or pushed advertisements for stress management apps or tools during the time when you are in or about to start or have just finished your commute. That's a relatively innocuous little bit of marketing, but it does demonstrate just how intimately tailored this data can be and how sensitively it needs to be handled. And so why, again, I'm using older adults here to to highlight the complex relationship between privacy and wearables is we have that example of the way in which your personal monitoring information is easily available. We're not even going to get into the vulnerability to hacking of a lot of these devices. But it's easily available to corporations, to data brokers. The older adults who are increasingly going to be depending heavily on these devices to monitor them and to age in place are also extremely vulnerable. This is where we're referring ourselves back to the Federal Trade Commission Act and its protections regarding deceptive or unfair practices. So, older adults are particularly vulnerable to targeting and deceptive advertisement, to targeted fraud that seeks to take advantage of sometimes individuals who are of declining rational capacity, but still have access to all of their financial accounts, all of their personal information. And so then when you think about this confluence of individuals who are going to become increasingly dependent on personal wearable medical devices to stay safe and to remain in their homes and to communicate with their caregivers, whether that be family or medical teams, with a growing focus. So at this time, and we can follow up, you get follow-up materials after this. You'll get plenty of citations about in the predominant privacy laws, the only major age-based protections for privacy are for children, for individuals who do not yet have the rational and legal capacity to consent to the handling of their personal information. They have special privacy protection categories under the GDPR and under CCPA, CPRA. Elderly individuals at this time do not. But what I would like everyone, as they're listening this, to consider is the fact that I would anticipate that specific privacy protections for the data of older adults that is collected through these devices is inevitable is a strong word, but is highly likely because as you look at the scholarship out there, being balanced on this precipice of an increasingly aging population that is receiving less social support, but is becoming increasingly vulnerable, we have to pay attention. We absolutely have to pay attention. And I would argue that the most rational response of both regulators and of corporate entities creating, marketing, using wearable medical devices is to proactively create privacy disclosures and privacy consent practices tailored toward older individuals in a caretaking situation, meaning that they have another individual, whether it is their medical care team or whether it is a family member, who is going to be accessing their data. Because it is challenging enough. Informed consent to accessing your data. We are also balanced at a time of change. Already, those are, they try to have privacy protections, privacy policies aimed at an approximately 8th grade reading level. They are still incredibly impenetrable for fully competent, individually operating adults. So, to appropriately get the consent and understanding of an individual who is monitoring themselves because they need to share that information with caretakers. I would strongly encourage any corporate entities to begin rewriting their privacy policies in advance of regulation to make it clear the way in which information about vulnerable populations is going to be shared. So let's get back. Yeah, oops. As we continue shaping the future of privacy protections for wearable medical devices, these are the questions to consider. And again, these are very broad, high-level questions, but they get at the heart of the future of these regulations and the future of the necessary privacy practices. Who is vulnerable? Privacy protections, marketing regulations, they are already written with an eye towards protecting the vulnerable individuals who cannot understand or protect their own privacy of information. As we move towards a confluence where individuals who have lost rational capacity are going to be more dependent on collecting and sharing their data, be prepared for a confluence of those regulations. Who can be identified? So, as you have heard about in other presentations, we are all working very, very hard on protecting identifiable information, biometric information, all of that, keeping it protected, keeping it locked down. But again, with wearable medical devices, we are looking at a specific category where they are designed to share information beyond the confines of your phone. They are designed to share information with a company that is monitoring and sending out alerts. That means that this data has to continue to exist in an aggregated form that is able to allow for significant re-identification of, as previously covered, highly vulnerable populations who are sought to be protected under different legal schemes. So, an important thing to keep in mind, how to prevent re-identification of particularly vulnerable population. Who profits or who benefits? This is not one of those areas of law in progress where we need to pull back the progress that's being made. There's a lot of, concern, scaremongering about various areas of technological process where the law has not yet caught up. Wearable medical devices are allowing people to live independently who previously would have been essentially required to move out of their home, out of their community, so that they would have a caregiver available to watch them 24/7. Now they can use their Apple Watch to do that. That is an enormous benefit to these individuals. Full stop. It is also an enormous benefit to the creators and marketers of these devices. So again, in the spirit of encouraging everyone taking a look at this, everyone interested in these devices and in the populations that use them, be considering my first two questions before there are lawsuits seeking disgorgement of profits, because this is a vulnerable population. And finally, who are the decision makers? As Ali mentioned at the beginning, as I mentioned at the beginning, this is an incredibly rapidly evolving area. Not quite artificial intelligence, but a lot of that is tied in here. We're aggregating, we're processing this data. So the enforcement, the pulling together of the consumer privacy protections with the vulnerable health categories, with the monitoring of medical data, that's going to come from the courts before it is going to come from the regulators. So that is why I'm putting this out there as things that the the corporate side needs to be aware of going into the next 10, 20 years with the aging population becoming a wider market for these devices. This is going to be adjudicated through damaging court decisions before it is going to get a roadmap from regulators. And this is an area where privacy regulations are going to be amended after there is a lawsuit about it. So better to be on the bleeding edge of the market and of protection of a vulnerable population before that is forced. I thank you for listening to this very high level exploration of the intersection between privacy, wearable medical devices, and essentially the future of our aging population and the roles of corporations, regulators, and lawyers therein.
Thank you so much, Rachel, for this really fascinating presentation. We are very lucky to get to benefit from your expertise and from the really carefully presented, very thoughtful presentation that you've put together. So thank you so much. It was really our pleasure to have you. Stay tuned for more BCLE recordings coming up.